I'm a future criminal barrister and I'm going to explain the sentencing of MP Mike Amesbury. These are the facts of the case. The MP was seen to punch a constituent outside of a pub at about 2 AM on CCTV. After being punched, the man falls to the ground and the MP continues to punch him a further 5 times before bystanders intervene. He's then heard to shout, open quote, "You won't threaten your MP again, will you?" Close quote. The MP pleaded guilty to assault by beating in January this year. Turning now to the sentence. There are sentencing guidelines for assault by beating, so this is the first place that the judge will go to when determining the sentence. The judge has to determine the culpability, how responsible the offender is for their offending, and the harm, how much harm has been caused by the offending. Turning first to culpability, for assault by beating there are 2 categories, higher and lower. The judge placed this into the higher culpability category as the MP continued to attack the victim on the floor while making verbal remarks. In terms of harm, there are 3 categories ranging from 1 to 3 for assault by beating, and the judge decided to place this into category 2. This is because there were minor physical injuries caused. This means that the starting point for the offence would be a medium level community order. However, there is a range of a low level community order all the way up to 16 weeks custody available. The judge then turned to the aggravating factors, things that make the offence more serious, and the mitigating factors, the things that make the offence less serious. The aggravating factors are as follows. The offence was committed whilst intoxicated. The attack was unprovoked by the victim. The attack was sustained whilst the victim was on the floor. There were spectators to the assault who may have been caused harm. Mike Amesbury makes a reference to being an MP whilst committing the assault, which can bring the reputation down for that role. Turning now to the mitigating factors. The MP is of good character, this being one blemish in an otherwise untouched career. The defence did advance mental health issues on behalf of the defendant, but this was not accepted by the judge as there was no evidence of this. The MP spent his life in public service. There was also a pre-sentence report prepared for the defendant, which suggested a community order and that the defendant was at a low risk of reoffending, which would have been taken into account by the judge. Despite the recommendation of a community order, the judge deemed that immediate custody was the only way to deal with this offence. The judge uplifted the starting point of a medium level community order to 15 weeks custody right at the top of the range. This 15 weeks was reduced by 1/3 because the defendant entered an early guilty plea, so his final sentence is 10 weeks imprisonment, of which he served 40% and then 12 months on licence.